Welcome to all this morning. It's 11 a.m. at Malaysia right now. So today we're going to have our first ever discussion involving 4 panelists from NBS Intellectual. And this time we're going to discuss about non-traditional trademark, or in another terms, we call it non-conventional trademark. So what is it about? Before we begin, may I ask you to help share. Hold on, yeah. There's a little bit of a laggy. Okay. Share this to your friend, okay? So for those of you who did not manage to register on the Zoom, this discussion can be found on Facebook Live at nbsmy/video, or you may scan the QR code. So for those of you who want the priority to ask questions, please join us in Zoom by keying in this webinar ID on the screen 97275645143 and the password displayed. Yeah. So this is our NBS first ever discussion, and unfortunately we can't, as panelists, we can't really sit together, but it's okay. We're going to do it virtually this time for the first time. If you have any question, please type it at the Q&A session, or for Facebook users, you can type it in the comments. We will try to check and accommodate to your question as much as possible. Yeah. All right. So this time we're going to talk about non-conventional or non-traditional trademark. What happens is that back in 2019, end of 2019, especially in Malaysia, there was a change in the trademark law. So currently, we are accepting non-traditional trademark. As we know, traditionally, trademark involves logo, words, graphics, and stuff like that. So nowadays, more and more other elements are quickly becoming the images of brands, right? Such as scent, colors, sounds, shapes, and so on and so forth. So Malaysia has amended its law in end of 2019 to accept this kind of trademark. And as an IP practitioner ourselves, we are quite perplexed with this introduction, and it's especially because it's quite new to us. So we organized this session to kind of discuss about the different types of the non-traditional trademark and have a discussion with the audience, if you have any question, to share more among us. Yeah. Let's talk about the first element of the sound mark. Yeah, sound mark. Let's have a brief look. Pretty much all of you are quite familiar with this sound, right? Ignore the graphic, just listen to the sound. I'm loving it, right? So this is the McDonald's typical sound that you see on the advertisement. Even without looking at the advertisement, you know it's McDonald's. What about this? Well, we have Universal Studio, Intel, and childhood memory recall. Windows startup sound and shutdown sound. Nintendo and Nokia, as we all know it. All right, so this is the one of the typical non-traditional trademark out there. Yeah, so Ivy, what do you think? Is it as important as the logo or word mark out there? What do you think about it?
Sorry, I can't hear you. Could you repeat the question again?
Hello, yes.
Hello, yeah, okay.
So we have sound mark. You see, without even looking at advertisement, just listening to the sound, you can actually recognize, oh, this is what brand, Nokia.
Yeah.
So, and this is getting popular nowadays. Do you think it is as important as the logo mark for businesses out there?
Yeah, it's very important for your business to be protected under the sound mark, because if let's say you have protected, that means no other people can use it. Once I listen to the sound, and then I will recognize it's your brand.
All right. So Anthony, how easy does this kind of mark get registered? You know, or maybe taking, for example, the Malaysian scenario, how do you actually file this kind of mark? Because it's sound.
Well, for a non-traditional trademark such as sound mark, I believe a sound mark is one of the most easiest mark to be registered. One of the most easiest mark to be registered, because how is the sound mark going to register? Because the first, similarly to traditional trademarks, the most important elements of a trademark to be validly registered still remain the one single word, which is distinctive. As long as the proprietor can prove that the sound which they wanted to register can distinguish between distinguish the origin, being that it belongs to that particular company or belongs to a particular proprietor, of course it can be registered under the proprietor's name. So how is sound mark going to be registered in Malaysia is basically of course you can't send a video clip like what we presented here to the registry. Of course the registry will not accept a video clip or even a MP3 or whatever you would send to record the sound. They won't accept it. What they would accept is in the musical notes itself. You put in a musical note whereby how the mark's going to sound in sequence and the distinctive part of your sound. You file that in itself, because under our new Trademarks Act, everything needs to be graphically represented. And how is our sound going to be graphically represented? Is by way of musical notes.
Also, like the do, re, mi, fa, so, those kind of.
Yeah. Yes. We call it the tactile notes.
Okay. So, but what we hear here are those famous sounds. What if, for example, I'm a new startup and I want to have a sound or a music that represents my brand, but it's not famous yet? Can I still do that to register a trademark for it?
Well, it is a non-traditional trademark. So for newly startup, no offense to all the newly startup, but for non-traditional trademarks, it has to be a mark or an element or sign which is very, very distinctive towards a particular origin. So for newly startup, I highly doubt they would have anything significant to represent their identity, because all of the marks we presented here has gone through history, has gone through a lot of different kinds of scenarios, have gone through decades before they are being widely recognized by the public and consumer alike. So for newly started, I wouldn't think they would have any sound which is distinctive solely to them, because I'm not sure how the registry going to identify or examine a non-traditional trademark such as sound. Solely based on the musical note itself is very difficult. That would be a very difficult thing to do in Malaysia. So hence why during the registrations, during the filing stage, we will still need to put a description for all non-traditional trademarks in Word, rather than only just a musical note itself. We still need to put in the description for it, like how you're going to sing the sound out. I have a good example, which is in Malaysia, the Hisamitsu has filed a sound mark in Malaysia, whereby they will mention how is the sound going to be pronounced in a way, like in a higher note, in a lower note, or in the flat note. So at the end of the day, once you understand the entire description, you would have a knowledge that the sound would actually sound like Hisamitsu. You will actually gain that knowledge for that particular sound. So that's how it's going to be spelled in Malaysia. So for newly startup, if you're newly starting up, of course you wouldn't have a sound which is widely recognized by the public. That sound could come from anywhere in the world. Hence why I believe a newly startup would have difficulties in registering a sound mark, let alone or other non-traditional trademarks, because even big companies having difficulties registering it.
Taking, for example, just now you mentioned Hisamitsu, or like, for example, McDonald's, there's not just note or tune, there is lyrics like I'm loving it. So how do you actually integrate those things into your sound mark when there is a sound mark?
So for sound mark, as you mentioned, the sound mark itself comes with the lyrics, but lyrics itself is not a sound. Lyrics itself is a word. So for example, McDonald's I'm loving it should more likely to go under the conventional way by registering the I'm loving it taglines. And as for the McDonald's, the sound itself, it would sound like dun 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 rather than I'm loving it, instead of the entire word and lyrics will be inputted in the trademark itself. So because if you follow it with the words, it will jumble up between the conventional and non-traditional trademarks. So for sound mark, we will exclude all lyrics by just inputting how the mark should sound. The word itself, the hisamitsu part word itself, is basically just to help the registry to understand it. So at the end of the day, what you get from the registration is just the sound itself, not the lyrics itself.
Oh, so the word should be a separate trademark.
Yeah.
Ah, I see. Okay. So what about variations? If a sound has a variation like this, you say one mark has few variations.
Yeah. Even though there are variation, like I know McDonald's, they tend to have variation towards their signature sound mark by going through different festivities. Like even during Christmas, they were very Christmassy. This has a ring to it. Chinese New Year has a really different ring to it. But all of those, at the end of the day, it boils down to the similar sound, which is the tune, the notes is still the same. It's just that they have added in a different kinds of festivity elements to it. So the sound is still the same. Hence why I mentioned earlier, whatever you file as a sound mark should only be the original notes which you were going to use. No matter how you vary it, at the end of the day, the source of it is still the same notes. If you have inputted a lot of Christmassy or festivity season, that is best to be protected under a different parts of the IP, which is not the story for today.
All right. Because yeah, it's kind of new to us, in this field.
Mm-hmm.
Maybe it's not new around the world in some ways. In Malaysia, it's definitely quite new to us to have this kind of marks.
Yeah,
so
definitely.
Actually, there would be a lot of confusion as to how to protect this kind of marks, right?
Yeah, definitely. Because until today, even our new law is a 2019 law. Now it's already 2021, and as at today's date, the non-traditional trademark files in Malaysia is only 142, which is very less in comparison to overseas. It's only in the region of hundreds after like more than a year since the establishment of the law. So I believe that two issues here involved. One is that the public of Malaysia is still unaware that the existence of non-traditional trademarks. Second thing is maybe agents such as ourselves or even the registry has not given any clear guidelines on how a non-traditional trademark should be filed or handled in Malaysia, let alone because there are still no decision yet released from the registry for non-traditional trademarks such as sounds or even scents and all those kind of really not really common thing we found in normal trademarks registration. So I believe even I myself, I'm still really uncertain how Malaysia is going to evolve in terms of the non-traditional trademark route. Divya, do you have anything to input?
One of the things that I note is, you see, when it comes to the Malaysian trademark itself, you don't actually require prior use. That is actually different compared to this kind of sound mark and all this non-traditional trademark, because you should be able to have distinctions. That means you should have used priorly. I think that is one of the thing that, aspect that non-traditional trademark actually brings to the Malaysian trademark system. So you, like what you said, you mentioned that, for it to get in distinction, that means it should be recognized. That means it has been used for a prolonged period. Like, for example, McDonald's and Universal Studios, all of them have used their music for so long that we can actually immediately have a recollection of the exact trademark we were mentioning. So, all those things actually requires prior use, which is very different compared to what it is naturally in trademark itself. You don't actually need to have prior use when we actually register a trademark. So this is actually an exception, I actually personally feel that this is an exception to the general trademark rule in Malaysia.
Yeah. Because non-traditional trademark, it will be very hard to infringe. That may be one of the possibility. It could be very hard to infringe because for someone else to flat out copy your notes, it's like it's a very daring thing to do. Because unlike conventional trademark, you want to copy it, people may vary it a bit. But for sound mark, the moment you copy it, you open yourself at risk to both copyright infringement and potentially trademark infringement. So it may be unwise to do so for infringing a sound mark. So it boils down to a sound mark could be a more powerful tool compared to a conventional trademark. That's my personal opinion.
That's true. I agree with that.
Let's look at another type of mark, that is the color.
I believe the color mark would be a more interesting topic for Malaysian. Yeah.
It's quite interesting to me. What do you think? Do you think a corporation or a company should be given the right to own a color?
Yeah.
What do you think?
I believe this question is a bad point.
Yeah, sorry.
I think this question, we need to get some info from Ivy itself, seeing that she's the one who constantly facing with queries from clients, from our companies. And do you have any? I'm really curious. How does your client feel about the ever since the coming in of the non-traditional trademarks? Don't your clients have any query in regards to color? Maybe how a bit of selfishness in Malaysian SME in trying to monopolize every single thing, even color. Do they have any such an intention? I'm quite curious.
Yeah, of course, everyone they wish to monopoly some of the thing or works that they have designed. And then sometimes I think before the non-traditional trademark apply in Malaysia, there's some customer asking about it also. So they wish to protect some of the uniqueness of their logo, the color itself. When they combine both, like the pendant color, they combine from A and B together as one color. So they wish to protect it.
Oh, something like Tiffany, how they come out
a unique color.
A unique color code.
Color as a code. What do you think, Divya? Should companies be allowed to own a color?
I think if it's distinct enough, like for example, Tiffany blue, the moment you see, until the color by itself is called Tiffany blue, you can go to a place and say Tiffany blue, they know exactly what it's referred to. So if it's distinct enough, I think you should allow the company actually to register it as their trademark. It's just that, we don't want companies to take a very basic or generic color and actually claim that, oh, you know what, this is owned by me. That is when the problem starts. But I think the examiners and also the registry are well aware of this, and they will go through a thorough examination before actually granting you the color for your trademark.
So then again, enough, right, Anthony?
I think basically you just need to take this with a grain of salt on the matter. Even though the law permits you to hold the color mark under you, but of course there are countless colors of with different kinds of name, with different kind of beautiful names for a particular color. But you still really need to think clearly, does that color solely belongs to you? If you yourself, like Tiffany and Co does, they did created the color, and that color is really distinctive to them. Of course, they are given the right to own the color. But for some other proprietor, whereby the color simply doesn't belong to you, whereby you simply feel that the color suits you, or for some even more superstitious proprietor, this color basically owns me or whatever, I want this color. That kind of, I would say, naive-minded proprietor shouldn't have this kind of thinking, because color mark itself is a very, 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 very difficult thing to register. This is not one of the easiest trademark to be registered, not only in Malaysia, but in anywhere else of the world. Really, for color mark, you really need to showcase that the color is really distinctive to your company and not to another proprietor. So I believe SME should really be aware of whether that color really, really is your own color.
Yeah, Anthony, recently I also found that there's Astro that did register for the color mark, right?
Yep. If you look at the Astro one, I think the example is kind of close to T-Mobile and Martel on the screen here.
Oh,
it's kind of, I think it's a lean towards Martel. I think they named their trademark as Magenta.
So Magenta by itself is quite a common color.
Yeah, which is why this is a very uncertain thing for Astro to register it. But at the end of the day, if Astro, of course, a refusal would obviously be issued. If my speculation is correct, on refusal will most likely be issued towards Astro, and this is just to no offense to Astro and to disclaim our liability. It's not that I'm cursing or cursing you that your mark will be refused or anything, but for color mark, because Malaysia is a newly is developing in terms of intellectual property rights. So for Astro to simply file a single color by itself is a very difficult thing to do. Even a strong company like McDonald's trying to register a dual color like the yellow and red is also having difficulties in the initial stage.
Right.
So what makes Astro so confident in seeing that the color magenta that they're claiming would automatically belongs to them? Not to mention, I think the previous color for Astro is not that particular color in my own memory collection. I don't think Astro initially born with that color. I think if over the years they subsequently changing system or changing modes into a different color tone, hence why they feel like that color really tells who are they, which distinguishes them. I think only then they would try intends to file that color. But like I said, refusal would most likely be issued against them, and they have the responsibility, and their lawyers or their agents would have the responsibility to actually try and prove that to the registry that this color really distinct towards Astro and none others in Malaysia.
Yeah.
At the end of the day, you still need to file the color under a particular class. If you manage to prove that in that particular class and all other telcos or all other broadcast company don't use that color, then they could get the mark registered. They could.
Or could I?
Yeah, Ivy, go ahead, Ivy.
Yeah, could I prove it with my evidences of use if let's say maybe I use this color for more than 5 years?
Yeah, that is one of the things to be considered.
Will be one of the things, but if it's not distinctive and you'll be using for years, I think it will still not come as a very heavy evidence, by itself. Because you can show that you use yellow as a common color as yellow. Like for example, Cadbury themselves, they've been using purple for ages. You know that the moment you see that purple bar, it's actually Cadbury. But yet they actually did not manage to actually secure the trademark for that color, Because actually, to be fair, that purple is actually quite a common color. It's just that they choose to adopt it in the packaging. So I would say evidence of use, of course, definitely, like any other matters, it will be important and it will play a role. But I think it all at the end depends on whether it's distinctive enough.
Yeah, distinctive is the most important element for trademarks alike.
Yes.
But for non-traditional trademark, as Divya said, the prior use or usage itself, it's not a major factor. I believe it's not really a major factor. At the end of the day, the registry will still weigh that. Yeah, I agree with you. You have been using it for quite some time. But are you able to prove that when the consumer perceives this color, it will think of you, but will they also think of another company? That's the important issue here.
Right.
But if the moment the consumer is able to think of another company, that means you lose the distinctiveness already. At the end of the day, the main purpose of a trademark is to distinguish from a single proprietor with another proprietor. So if that particular color mark fails to perform its duty, it automatically loses its distinctiveness. I'm not disqualifying the usage here in Malaysia, but it's very reluctant for the registry to accept you as a sole owner of this color in that particular class. I believe that's what Divya trying to bring up in this matter.
Right.
Yeah, evidence is it's helpful. It's helpful, but it's not absolute.
Okay. But I'm also sure because like each company has a color, like Louboutin and Coca-Cola, they have a different shade of red, and T-Mobile, Mattel, they have a different shade of magenta, and Tiffany has blue. You see, I'm quite skeptical how this can actually differentiate because color has so many shades. Sometimes it's hard to differentiate. And the Pantone only has 1,000 colors. If each company takes one color, then it would be quickly exhausted. Right? Although it's quite interesting, wow, red is hot, passionate. Yellow like the McDonald's is happy, and cold, blue color, and some rainbow colors like Google.
Yeah, I do agree. A color would be exhausted at the end of the day if everybody trying to claim a single color. But all this is at the end of the day, I'm no artist. I don't understand what color mixed with what color will come up with a new color or not. But that is up for all the proprietors to go and do their own research and digging and due diligence whether I mix this color and this color, will it come up with a new color or whatever. But if they really manage to create a new color, then why not? Like Tiffany does, they really do create their own color. They even create a distinctiveness out of it. Of course, they can get it registered, no problem with the Tiffany blue. But for other proprietors, Coke has been using the color rate for quite some time, but I'm not sure whether they have the mind to actually monopolize the color rate itself. That I'm not sure. Yeah, so at the end of the day, as I mentioned earlier, a single color by itself is a very difficult to register. If you mix and match like 3 stripes of color and above, I think it would be more relatively easier because you combine a different kind of variation. You did position it and you did have a sequence to how you place the color. I believe that would be a more easier way to go and register a color mark. A really good example would be 7-Eleven and Family Mart. The 7-Eleven, if the moment even without looking at the word 7-Eleven, you look at it solely on the 3 color stripes, you would know that it's 7E. And for Family Mart, it's even more obvious. The moment you look at the green, white, blue stripes in horizontal line, you will automatically know that even without looking at the Family Mart, you will know that it's a Family Mart. That is what a color mark should perform in such a scenario. And plus they have 3 shades. Yeah, they have 3 shades of color, which is it gives the registry a more reason to accept your trademark because you're not monopolizing a single color.
Right.
Except in the case of chicken, right? They have started since so it's been so long. The color is named after themselves.
Yeah, something like that. But
because if you notice, food and beverages, they always, if you all notice, they always adopt this yellow and reds. Apparently, it's actually supposed to play in a consumer's mind that, you get hungry and thirsty. Those are the colors. That's why they tend to actually adopt those colors. So if you look at the lot of actually food and beverages, they use the trademark, they use yellow and they use the same red. So I don't think by itself, even Coca-Cola, if they go on the basis that they want to claim that color, I think it will still be difficult for them, even though with so much of use that they have,
Exactly. Plus, in the mind of businessman, I believe Ivy is very, very, very more knowledgeable in this. In terms of businessman mind, right, they really do tend to go according to the market trend and festival seasons. Like for example, during Chinese New Year, everything single beverages will obviously turn into 2 shades of color, which is yellow and red. This is how are you going to claim a color mark which solely belongs to you when you yourself constantly changing the color of your product. So this itself is not a good way to maintain to showcase to the public or to the registry if you want to register that this color belongs to you because you're constantly changing it.
Yeah.
Don't you agree, Ivy? Your client would obviously, when they file a trademark, they will be reluctant. Should I color claim it or should I don't color claim it?
Yes. And then one more thing, since there's so many color and then those brands wish to monopolize it, but these color are created by the God.
God, yeah. I don't think it's God. I think it's
created by the God. So how they can monopolize for it?
Yeah, something which is made it's an act of God. Of course, you can't monopolize it. I think it's similar to patents. Everything is act of God. You can't patent it. It's same thing here.
Yeah.
As long as the thing doesn't belong to you naturally, or you gave birth to it, of course you can't own it. Of course you can't possibly telling, that lady born a child, I like his feature, I want to claim him as my child. It's a similar concept. Of course you can't say it that way. It's similarly to color mark here. So if you manage to, like I still need to reiterate, if you manage to combine a few shades of color in as one, of course you are given the best favorable chance in getting it registered.
What about service line? You see one example here. I think this is pretty much very familiar to Malaysians and ASEAN citizens.
Yeah, let's throw the question to the public and see whether they manage to, let me go into the chat box and see whether they could answer it.
Yeah.
Any response? What brand is this?
The one at the bottom.
Let's have a look at Facebook.
Let's have a look whether someone answer it. How many attendees are we having today? Who is Mayfan?
Wow, Mayfan, very good.
Okay. All right. Oh, Mr. Bernard actually answered Grab as well.
Grab.
Yeah. Now, okay.
Uber.
Very someone.
Uber. I think he pretty much don't know the color of Uber.
Did someone say Uber? Oh, okay.
Who said Uber?
No. All right. If someone said Uber, I want to go to his Facebook page and ask him, how do you perceive Uber from green? Okay. for those who answered Grab or thinking about Grab, I want to pose a question to you. If I removed the wording and the car itself, would you, without any knowledge, without any hint to you, would you still think that the two colors, the two shades, green shades of color, would automatically lead to Grab?
Take away the word and car, just the green.
Take away the word, take away the
recognize
car. Would you still think it's? Come again, Marcus?
Would you still
were saying something?
associate with Grab?
Yeah.
So
Would you
take
still
away-
associate it with Grab?
Mhm.
Someone who, those who answer in the column may answer it. Would you still associate the color green with Grab? Please don't be
Yes or
biased
no?
with this question. If you answer yes, then I'm okay, bravo. Grab has attained a distinctiveness, but please be objective minded when answering this question. If I remove the word "say hello to your everyday everything" app and the word and the car, would you still think of Grab? If I just show you the shades of green, would you still think of Grab?
For me, no. I think
Yeah,
many
definitely
brands-
no.
For me, no. Yeah, for sure.
Yeah, and because Grab has a special font that they always use, which is like
Yeah, exactly. And this is a very good example to our SMEs. The moment I remove some distinctive feature from the representation, you would lose all sorts of, you would lose your thinking, the saying that, oh, what color does it belong to? Is it belong to some eco-friendly company? Or is it belongs to some environmental environmental foundation? Because the green is a very eco thing. So
True.
the moment I remove those two features away from the representation, you would lose your thinking. You would have doubt. Color mark doesn't allow doubt. The moment you have doubt, that company doesn't own that color. I'm not excluding the rights for Grab using the color green. It's their rights to use any color they want. But the moment I remove those features, you automatically loses the way to think of Grab. So if any Grab viewers are viewing, please don't be offended. Okay. So if Grab, for example, if Grab were to file this, removing the shades, removing the cars and the word to file for a color mark, it will most likely face an initial refusal. That is, I could say for sure.
Yeah.
But how is Grab going to prove it?
And Nathan also brought forward another thing. She said that, the font is one of the things that actually gave away that is Grab. So you can clearly see that the stylization is what actually matters. That's what actually made them associate it to Grab, not just color by itself.
Yes, exactly. A few elements actually made the representation belongs to Grab.
Sure.
So this entire representation, I could say it can be protected under the copyright, but definitely not under the color mark itself. Because after all, those two shades of green doesn't belong to Grab. That's what I could say.
Looking at green, I have a curious question, because green is always associated with plants, grass, and so on. If a person is operating a farm, let's say, and they want to add the green color as a mark, would it be a higher chance of refusal or something? Because it's so.
I didn't quite catch that. Divya, did you catch the question?
No, what he's saying is, if the color green by itself, because it's very associated to nature and a lot of farms and everything, he's asking whether the color green can be associated, can it be said to have direct reference? Is that what you mean?
Oh, I see.
Yeah, for farm SMEs, farmers who want to apply green as their mark.
For non-traditional trademarks such as color, I highly doubt that a direct reference would apply. Because
I don't think so.
It gives no indication towards the goods or services. It really doesn't give any indication. You said it's a very common that thing for the public, for a human being to ultimately perceive the color green. Yes, it refers to trees, it refers to leaves, it refers to something green, it refers to vegetables, for all that I care. Okay, so but those are education or academic education since we're born, that we must color leaf with green. But does all leaf comes in green? I don't think so. Yeah. So for a color mark to act as a direct reference, I highly doubt that the registry would take this step in saying that, oh, you're registering the color green is direct reference to your product. I don't think they would be that rash or that hard-headed to cite direct reference under a color mark. I think more likely would cite merely the absolute grounds for distinctiveness by saying that you are not this color doesn't solely belong to you. Yeah, Divya, you were saying something, Divya?
Yeah, I think in terms of direct reference, I think that's not the way they're going to go about, like what you mentioned, that's not the way they're going to go about refusing it. Because the color, but they may look at the fact that green may be common among those traders. Like for example,
Yeah.
farm, all those who has farms and everything. So I think it still goes back to distinctiveness. Because
Yeah.
if
You can't
if you're
distinguish
something
one from another.
correct. So it still doesn't go to the direct reference part of it. It's actually still referring to distinctiveness. If other traders are commonly using those colors to represent their this one, so you lack distinctiveness. I think it still go on that basis rather than direct reference.
Correct, exactly.
Okay. So
I hope the listener or the participant is not being confused by our gibberish and constantly, like, we are quite, the more we go into it, you will see the more reaction we are giving.
Okay.
I
We're
mean,
just
really,
passionate about whatever we are talking.
Seriously, as MBS legal advisor, I seriously need to disclaim any potentially liability we have in this
Yes.
particular seminar, because this is very new to us, in not only to our company, to all IP agents, even law firms in Malaysia. It's really quite new. Plus, if anything we said here offended anyone, please don't take it personally, because this is solely for learning purposes.
Educational
We are all
purpose.
still
Yes.
learning. Yeah, we are all still learning.
There is audience who say the color looks like Hari Raya. So we've got a question.
Exactly, Hari Raya.
We've got a question as well. In your opinion, what do you think? Maybe for sound mark and maybe color mark, for marketing purpose, do businessmen actually need color or sound mark? Yes or no? Just a quick yes or no.
I think
Ivy?
I think no. I
No.
think no. I
Yeah.
think no, especially for startup.
What about Ivy?
I think this question is best posed to Ivy. What do you think your client? Do your client really need a color mark or even a sound mark to market their product?
So far, no.
Not really.
Oh,
I do not really.
Ivy is.
No.
I really don't know.
Maybe it would be interesting to look
but if you
at.
ask me personally, I really think no lah.
I think what, if you associate your brand to this color over the years, of course, it's not something that probably why you mentioned startup, because startup actually they want to see the recognition quite fast. So when they, when you want to assign your mark with a sound or a color, so you may not be able to immediately get the recognition. But I think over the years, you may be able to, if you're constantly using, and of course, once you're no longer in that whole startup phase, you already gain a lot of wide recognition, then maybe you will, all those color marks and, sound and everything will come into play and it will be more for you.
Maybe it would be interesting to look at the next mark as well. Shape, we group them together because they're closely related. Shape, packaging, pattern marks.
I believe I think the current 142 trademarks we have in Malaysia register, I think majority of them, I could say 80% of them are shapes.
Shapes.
Because this is I think because the last I saw there's only 80 something and 60 of them were shapes. I believe now it's 142. I think 80% of them would still be shapes. Because we unlike developed country where the people there or the citizens there, they have a way of thinking that, oh, maybe I could copyright it, I could trademark it, I could patent it for all kinds of things which appeared from their product. We as Malaysian, we are quite straight-minded. Whatever we see, we will try to protect it. In for example, a product, which the most obvious thing would be the shape. We wouldn't go and think further whereby, oh, the internal part of my bottle has a particular specialty whereby it could pose a function. Maybe I could protect the patent. They rarely we will see a proprietor, especially in the F&B industry or even fashion industry. They would hardly think of this thing as a necessity. So they will straight away go for the most obvious one, which is a shape. Hence why you can see in the 142, majority of them are shapes.
What about for like Toblerone's case, without the package, just the triangle shape of the chocolate or the 4-bar Kit Kat, without the packaging, is it still recognized as a trademark?
I'll let Divya answer this. I believe Divya has some research on this.
Yeah. Because when you look at Toblerone, actually successfully, they have actually successfully, they are known to actually be able to register it as a trademark. Actually, in fact, Toblerone and Legos were one of the first few that actually filed for non-traditional trademark. They actually filed the packaging by itself. So I think personally that, the redesign of Toblerone is very distinctive. I don't see it in any other traders using the same kind of shape. So I think the Toblerone by itself, where else I think KitKat, they were unable to secure, if I'm not mistaken, they're unable to secure the two bars.
KitKat was not successful.
Not successful. Because
not
I think
successful for
something,
KitKat.
because they have a variation of it. They usually have 4, they have 2, depends on how many people want to eat that, basically. If you want to share with your friend, maybe you take 4, something like that. So they have a variation of it. So they were not able to secure. But Toblerone, they will have been successful with securing their trademark.
What about you?
Hey, if you ask me, KitKat, the chocolate bar itself for KitKat, I think majority of the chocolate bar holds a more similar rectangular shapes.
Yes.
So I doubt it could fulfill a distinctive part, if you ask me.
I have a question.
Yeah.
Since industrial design can be protected, this kind of shape, everything can be protected under industrial design, why should I still need to register as a trademark, as a packaging mark?
Divya, do you want to answer that?
It's usually because of trademark actually protects for a longer period. It's all because of the period. Trademark, if you look at it, you can protect for 10 years. And after that, it's renewable for another 10 years. In comparison with industrial marks.
But what about the difficulty, for example, for a new startup with a unique shape? So how difficult is it to register an industrial design compared to a trademark?
Or do I need to use some time?
Okay, I think startups should think of it this way, because as me and Divya are constantly putting at the side of our fingertips, the side of our mouth, we keep saying that trademark requires distinctiveness. Okay, that's the most important thing. So if a startup is uncertain that this particular shape is whether it's distinctive or not, I think it's best to go with the industrial design way, because the industrial design way they only examine it on terms of novelty. As long as they deem your design is new, they will get grant you the rights to the design. And a design can be renewed in Malaysia every 5 years, up to a maximum of 25 years. So after the period of 25 years, you would have gained recognition in terms of the shape. So in that moment in time, the moment your design expired, you can transform your rights into a trademark. Because
that's a good idea.
If you have undergone significant, you have gone through 2 decades of that particular design, assume you are not changing your design over the 2 decades, then no one is stopping you from going for a trademark, because you could more obviously have gained recognition in terms of the shape, like how Toblerone did. They did not change their shape over the past few decades. Ever since I was a child, I see this shape. Until now, it's still this shape. That is what decides distinctiveness.
Right.
Can I use the same method for pattern? Like, these are so simple.
Pattern? Or pattern? I thought I heard patterns. Yeah. The fabric pattern is the same issue. It's the same thing. Like Burberry and I see, even without you naming it, I know it's Burberry and LV over there. That's how distinctive they are. Originally, these two are. I'm not sure, because I'm not born at that period in time. I think I can know for a fact that these two was not a trademark in that moment in time. Maybe it's more likely it's protected under a copyright or industrial design. But they do expire. This is a very good example whereby they transform their pattern into a trademark, which is why you can see they file a trademark in this particular rectangular, square shape in the trademark itself. You can actually locate these 2 trademarks in the Malaysia register system.
Right.
So they've been registered in Malaysia for quite some time.
Yes.
Yeah, for quite some time, I think.
And that's before Malaysia start to recognize non-traditional trademark. How
non-traditional trademark?
No.
Yes.
Yeah.
Okay.
Before Malaysia start recognizing non-traditional trademark, these 2 are already in place in the register, which is why I think these 2, rather than you said it's a non-traditional trademark, I would rather deem these 2 as a normal conventional trademark, because they are graphically represented. They hold a significant distinctive element in terms of the representation itself. So why not just go for it? You can treat it as a normal logo. For all I care, you can treat it as a normal logo. Just file it as a normal trademark. So for these two to be named as a non-traditional trademark, I'm not sure whether the registry will categorize these two as a non-traditional trademark after the new implementation of the system.
Right.
But for I don't think these two should categorize under the non-traditional, because these two can be easily registered under the normal way.
Yes, it can be a conventional trademark by itself. It's not necessary for you to go through the non-traditional part in the first place, because it's easily registerable under the normal way.
Yeah, considering what I said earlier, if you want to register a non-traditional trademark, you need to give a whole lot of description on what is a pattern, how does it arise, what consists of the distinctive element. You need to give a short essay on in your application. Then why not just go for a traditional, the traditional way, by just simply filing the application with the representation, just name it as figurative.
I see. All right, let's move on to the next category. Oh, this is hard. Positional mark. How do you claim a position as a mark? I mean, well, like Levi's has a history of putting their labels here at the right pocket, their pants, right?
Yeah,
but
right
how do they actually own that position? I mean, like anyone can put a label there, right?
Not after Levi's managed to register it.
Yeah, if Levi's have managed to register that is their positional mark, then I think it excludes everybody else from putting it there.
From putting a label there.
Yeah.
Should we also include the description as well for this kind of positional mark?
Yeah, you need to include a description as well as the you look at the picture, right? You need to, like, the jeans by itself, you will be presented in a dotted line. Only the label itself will be presented in a rigid line. So what I know about Levi's, they are claiming a red label being imprinted on the right back pockets. That's their application. They actually really claim the color red as well. They claim a red label being imprinted on the back pockets. And no other jeans or no other class 25 product in Malaysia, if assuming Levi's managed to register in Malaysia, could use a similar position. Or no other jeans seller in Malaysia could use that position. That's what the positional marks is for.
I wish to stress also the fact that Anthony mentioned dotted lines, because if you don't actually go and dot your lines and you don't claim exactly what are you trying to claim, then it will seem like you are trying to claim the whole thing. That is the reason why the dot is actually meant to work as a disclaimer itself. And there are some cases in where they did not dot it, they actually drew it as it is, and they put the mark as, for example, a positional mark as it is. They say that, are you trying to claim the whole thing? And it was refused. So it's very important if you want to claim positional mark to keep it dotted, so that you're disclaiming that you're not claiming the jeans by itself. You're claiming the fact that Levi's is going to be at that side, at the pocket.
Yeah, it's very crucial. It's a very crucial part.
Even if you take the word like Levi's, if Levi's does not appear there, just the red label.
No, Levi's didn't put the word Levi's there. It's just a very simple red label.
Red label, that's all.
So
without the word.
It's still Levi's mark.
Yeah. It's found under Levi's. It's found under Levi's. Of course, it's Levi's mark.
What about Adidas? It's like this position. I found this position like quite common. Like many of the companies, they put their logos or their patterns at.
Because it's very limited for shoe to have to put a particular thing on shoes. Yeah, it's very difficult. Where would you put a thing on the shoe? Like for
it's so limited, it's so
small.
They
put it on the sole. It's very small. You put it at the bottom. So at the end of the day, positional marks, in my opinion, in my personal opinion, is really unnecessary. it's really unnecessary, because why on earth you want to monopolize a single position? Because for shoes, I highly doubt Adidas will get that positional mark, because the 3-stripe, is your trademark, your normal trademark. The 3-stripe thing is your normal trademark. But would you want to go over the trouble to even claim that position for your shoes? You are trying to limit a lot of you are basically limiting competition, your competitors, by not putting anything in that position. Yeah, of course you can't put 3 stripes, but 3 stripes are very, 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 very common. Even Adidas mark got revoked in the EU for the 3 stripes.
Yes.
So I really doubt you want to claim positional mark in Malaysia. It's a very counter-effective thing to do, not to mention waste of money. Unless you are really, really like Levi's, you want to claim that position in the back pocket. Do you think it's really even worth your time and effort to go and sue someone just because someone put a label at the back pocket?
Yeah, correct.
Now we bought Levi's jeans for the durability, for the comfort.
Yeah.
Is it comfort? I'm not sure. For the comfort, for durability, not because you put your label at the back pocket.
Yes, that's true. And I've never went to a Levi's store and checked, oh my God, does it have
Yeah,
the red
label
tag
at
in
the
the
back
back
pocket.
pocket?
I won't check that.
I don't think I've ever done that. So I think this is very unnecessary. I would admit it's very unnecessary for them to go the extra
I
step.
really think it's a bit unnecessary for positional mark.
Yeah, like when I buy
But then
shoes,
again, they are
important to look
come again,
at,
Marcus.
huh?
Okay.
Like when I buy shoes, I think
you
it's important to look at the sole. Like these Spanish art shoes, the logo is positioned at the bottom, right? Do you actually
Unless-
think it's important?
Yeah, for shoes, if you look at the sole, unless you're buying a really famous brand where all of their soles are colored in red, unless you are buying that shoe, you need to confirm whether it's red.
Yeah, yeah,
I
sure.
forget that they're selling heels. I forgot what's the brand name already. It's a very famous thing.
Louis Vuitton, ah?
Not
Is
Louis
that what you're referring
Vuitton.
to?
No, not LV. Definitely not
Louis
LV.
Vuitton.
Yeah.
I think in front there's a color mark which shows the name. I forgot the name already in the earlier slides.
I think it's Louis Vuitton.
Really?
Yeah.
Where
I
they
think so.
colored their heels in red.
Red, yeah, the
No,
black and red.
yeah.
You know, they're very famous for their red. So I mean the
So-
red heel. Yeah,
Yeah,
yeah.
that is. I believe that is a
think it's Louis
positional
Vuitton.
mark. Yeah, I think that is a positional mark.
I see. So it's not advisable to file a positional mark even.
Especially for startup, because we are focusing on startup, we are helping SMEs here. So I won't side with the big corporation. I won't go against what their mindset is. If they feel comfortable, they wanted to protect this position is important to them. Of course, I'm not. Who am I to go against them? Which is my reasonable advice here. Positional marks is really unnecessary for startup, especially for startup.
What about motion? Let's have a look at this. Future is exciting, ready? Who can take a guess? What is this mark?
I think this brand Malaysia would unlikely to know. This is a UK brand.
Yeah,
isn't it?
because they're not here. The providers are not here.
Yeah.
Malaysia will call it the Petronas, right? It looks like a Petronas logo.
Yeah, for me it looks like Petronas lah.
But Petronas is green.
Petronas
This is
green.
Vodafone,
Yeah, this is Vodafone.
telco company in Europe. I think Malaysians would know this.
Yeah, especially with the work from home.
When you watch a lot of Netflix, right?
Netflix. Yeah, that's the only thing we can do for now.
Yeah, so how do you actually file a motion mark? Something that's moving. How do you actually get it protected? Like how?
Okay, for motion mark, of course, like I said, you cannot file in a video. Definitely, you cannot file in a video. We can't even help you file. We can't even file a video. We can't even put it on the form. So, how are you going to file a motion mark, or we can call them the movement marks? So, in order to file this kind of marks, you need to showcase a sequence of motion, how from the beginning until the end, a sequence, like something like on the screen now. From the initial stage, you need to showcase the first stage. It's something like a flip art, whereby the moment you flip it, it actually moves in your hands, the flip art.
Right.
So it's basically this how you should have in mind when you're filing a motion mark. So a sequence is very important. Of course, this is also, you need to be concise, precise, and need to be really, really legible in order for it to pass the formality stage. Even you need to really, really be aware of this kind of formalities.
Right.
That's how a motion mark should be filed.
Well, the next one is.
I think we are going towards the rare traditional.
Yeah, I think the motion
non-traditional.
programs are quite rare. I think even MasterCard don't even know that they've been using these since very long time ago. They don't even know that this forms part of their trademark. Is that so?
Yeah, for hologram marks, in my understanding, hologram marks, because if you look at hologram mark, this is one of the holograms. And the requirements for filing a hologram mark, you need to able to showcase on the hologram is actually match your original trademarks, because after all, hologram is a reflection of the original thing. Yeah, for hologram marks, the requirement is your hologram needs to reflect in precise position in all angles. The moment you cannot reflect exactly the same in all angles, you would lose the formality part. Which is why this is one of the simplest hologram, which is just reflect on it. So I don't think this actually reflects in exact mirror image on the hologram because there's a globe there. So I'm not sure how Malaysian going to examine the hologram, and I don't see any hologram being found in Malaysia yet.
Yes, and I think in EU they expect you to actually provide some views of the hologram where you actually can see, you start seeing your trademark itself.
Google has this in the EU on their gadgets. I think they filed in the gadgets class 9 classification.
Recently filed, I think.
Yeah, quite recently. And it bears a symbol G. But what we are seeing is the hologram on object. What about those that you project on the air? Like with 5G and 6G is coming, right?
Yeah, exactly.
What I mentioned on the edge. What about those holograms?
Yeah, what I mentioned earlier, exactly. Why I mentioned angle is because we need to, hologram also consists of those projections, which is why the thing you project need to reflect exactly as the original thing you wanted to do. The angle, which need to concisely showcase on all angles, it reflects the original. It's actually the same thing as how you apply it. So basically, you need to give them a figurative representation as a reference, and you need to name it and position it and describe it. How is it reflects the original?
Wow. It's
yeah, hologram, I think is very unlikely we receive any again. Not to mention we after all this year, after 1 decade has passed, I think MBS still has a non-traditional request yet from our clients.
Yeah.
This is so rare, right?
It's very rare.
I think if they are not, it's not to mention rare. I think if they are not able to, they don't see the necessity. I think, or they don't think they have such a trademark in their belt, under their belt.
What about the appearance of the store? Like Apple got it registered in the US, right? Their stores.
Yeah. First of all, the appearance is not mentioned in the Malaysian Trademarks Act 2019. Appearance is not one of the sign defined under the Trademarks Act. So this is purely for your information to the public. So I need to mention that first. This is not available in Malaysia yet.
Yes.
And it's an interesting discussion during our rehearsal yesterday. So I believe let Divya go ahead first. What do you think about appearances? We do receive a lot of inquiry.
Okay, like what you said that the new Trademark Act does not mention anything about appearance. At the same time, there is no Apple store also in Malaysia. So, we are actually lacking a lot, compared to many other countries. A lot of brands have not actually entered. Like, for example, Apple store have this clean slate, clean look with rectangular tables and everything.
View
windows and all that. So we don't see it in Malaysia yet, at least. They've not entered the Malaysian market. So probably why we feel that, probably why the Trademark Act also reflected that, because a lot of brands have not entered and we have a different mindset. A lot of companies, actually, they have a different look for each branches. For example, if you go to a higher end places, I think we discussed this during the rehearsal. You go to a higher end place, they will have a different outlook, which I personally, as a Malaysian, I would say that I actually like that, because I may want to eat the same food, but I may not need the same ambience. I may look for a different ambience. So when you want to go for an appearance, you want to file an appearance as a trademark, it has to be uniform. It has to be uniform everywhere. So is it actually important for you to be that uniform? For me, I think it's not necessary.
I believe Ivy have a lot of clients with this kind of issue. She even has clients from the bubble tea industry. We don't mention names here, just that know that it's a very famous brand, Ivy. So do you have anything from your client side you want to reflect here, share with the public?
So far, I did receive some requests that client wish to protect. They come to me and say, "Oh, this is a unique design only in my store. I want to monopolize it. How can I protect it? I don't want people to do the same thing as mine."
Oh, I think I recall this client.
How can I protect it?
I think I recall this client.
Receive this kind of inquiry. Yeah.
This client actually sells high-end gemstone furniture.
Oh, I see.
Yes,
Yes,
yes.
I think one of their lamps actually cost up to tens of thousands just
Mm.
for a single lamp. I think this is one of it. IVD came and asked me about it. They want to protect the appearance and
Parents, the motion.
yeah, the way they present their expensive lamps in the store. But during that time, we don't, not even now, during that time as well as now, we don't have this kind of law to protect that sort of appearance. Because
That's right.
why I said so, because I told the client, this is your business concept. And business concepts are meant to be improvised. I wouldn't
And
use the word
evolve.
copy, are meant to be improvised and used by a lot of different kind of competitors in order for you to compete against each other.
True.
And if we were to have imposed this kind of law, would it contradict the competition law in Malaysia? That is up to another debate amongst all those top-notch lawyers or whatnot. So I'm not in place to actually debate on this. Would it go against that kind of rules and regulation? Is it viable or feasible to impose this kind of law in Malaysia under the Trademarks Act? Not to mention, is it really, really required, like Divya said, is it really necessary to protect Malaysian from this kind of infringement? Is it easily infringed by another? As mentioned by Divya, an appearance of a website or retail store needs to be consistent. And Apple, after all, I think three of us, Marcus, me, and Divya, all studied in the UK, and we look at a lot of Apple store in the UK. All of them actually really, really are an exact mirror image of one another. It's just the only thing different is in terms of the size. It's only the size is different, but the appearance itself, the vibe, the ambiance it gave out is exactly identical. So can the Malaysian SME or even Malaysia big corporation manage to do that? Can they achieve that particular achievement? Can they maintain that consistency in terms of their appearance and style? I know they do have franchises. They set up outlets in a similar way, but is that similar sufficient to fulfill an appearance requirement? That is another issue here. And to me, the appearance, as I advised to that client, it really is your business concept, how you present your business style. And people, your competitor will want to use a similar concept as yours because you are competing against each other. You are selling the similar product, you are carrying a similar services. So it is very, very doubtful that a similar competitor or similar service provider would not clash with each other in terms of business concept and even in terms of how they represent themselves in the market. So to me personally, I feel the appearance limit is best to be excluded from the trademark law protection. Otherwise, the Malaysian court will be very, very hard, having a very difficult time in trying to sort all this nonsense out. Oh, he's copying my shop lot image, my appearance. I want to sue him. It's a very trivial thing to do in Malaysia.
I think Anthony, previously you mentioned that you open a floodgate, everyone will start claiming, oh, you know what, that shop looks exactly like mine. You know, everybody will open, oh my God, courts will be busier than ever because everybody will claim that, oh, that person copied me and everything. So I think, and on top of that, we are also dealing with startups and, you know, usually SMEs who will usually have a smaller fund in the beginning. And they may create an outlook and appearance of the store based on the funds they have. Of course, as you evolve, you want to improvise that appearance. That's usually the mindset usually people have. And if you are going to claim appearance and you're very interested in keeping it uniform, you cannot do that anymore.
Exactly.
It is how it is.
Yeah, David actually reminded me of one of our cases which we passed to external counsel for litigation matter. Is a wellness center. Initially, this client came to us and asked for pre-litigation advice on the matter. We actually one of the issue was actually appearance. One of this particular client, the former employee of this particular client, actually went off and set up another business which is in direct competition with our client with a almost similar appearance and ambience. You know, but I did told the client, ambience and appearance for a spa-related, wellness center-related services are, in general, are more or less the same. It gives the same vibe. It gives you feel comfortable, you feel relaxed in a spa. So it's very doubtful for a spa center to go like a clubbing center. It's really impossible. So that is what I advise them. Yeah, rather than, in my opinion, rather than setting this particular appearance in a statutory instrument such as the Trademark Act, why not just go by way of common law common law thing, whereby, you know, the purpose of the common law is to remedy loopholes, which is not provided under the statutory instruments. Why not just leave it until for the common law, for the courts to decide whether this thing is actually a pass off of my reputation in terms of this.
Yes.
Let the court
So
decide.
in that circumstances, we actually look at bad faith, whether the person actually, you know, copied. So I think, yeah, you're right. I think it's not necessary for you to include it in the statutory aspect of it. And you leave it to the common law. If they manage to prove bad faith, that this person indeed they want to confuse us, then leave it to the common law to actually judge whether you're passing off the business.
Exactly. We do have misrepresentation here. We do have common law of passing off. We have a lot of different kinds of common law. After all, Malaysia is a Commonwealth country. Unlike other countries where they want to set it rigidly to the people that accept it. But whether Malaysia would accept it, that's a different story. Not to say accept it, would Malaysia abuse it? The word abuse is a keyword here. Because the moment you abuse the justice system, it's the end of the Malaysian judiciary. So this, I think, is my own personal opinion that I feel that this appearance part should not be included in our Malaysian statutory instruments, which is a good thing they did not include it, which is a good brava for all the Malaysian IP lawyers here when they are discussing about the law here.
So things don't get so complicated.
Yeah, don't make things complicated. We have enough complication in Malaysia as it is.
One last thing, I'm a little bit quite perplexed with one more kind of trademark that we didn't show it previously in our slides because it has no sound, it has no look. It is the scent.
Oh, the smell. Okay, the smell. Okay, the scent.
Yeah, how do you get a scent trademark, and how does it even represent an identity of a brand?
I understand why you didn't put it in, because you can't put things which you can't see.
And I can't even smell it right now.
Okay, for scent mark, I think I first need to advise the client. Scent mark is I think it's one of the non-traditional trademark which most likely to give out direct reference or descriptiveness towards the product and services they're selling. Hence why for scent mark, for those beauty industry would most likely to face an issue with this kind of trademarks, because they may have a misconception. Oh, this perfume, I have a really nice smell to it. I want to register it as my own distinct smell, but you can't. But regrettably, you can't, because that is what you're selling. You're selling scent. You're literally selling scent to the public, which is why perfumery is not a good way to go for scent mark. Even beauty products like facial cleanser, as long as everything which comes under class 3 or anything where the aroma is their selling point, it's not advisable to go for a scent mark. A very good example would be in the EU or UK, where they filed a football field as a scent mark. Football field itself is a class 41 or 44. I can't remember. I mean, what is the thing for entertainment? 41, yeah. 41 for entertainment and sports. Okay, so they filed under 41 for the football field, when the scent mark itself is actually named. They describe the scent mark as a freshly cut field. That's, I think it's a baseball. I think it's a baseball. The baseball actually smells like that. A baseball don't give out any scent other than a stinky smell. But that baseball actually gives off a scent, which is why it's distinctive towards the baseball. I think it's a class 28 mark. It gives out a good scent.
Any field or grass that is cut will have that smell. How do they own that smell?
Exactly. But the main point here is the product they're selling is the baseball.
The baseball, not the grass.
The baseball, not the grass. The baseball smells like a freshly cut grass.
I see.
Exactly. That's what, because the baseball doesn't have smell initially. So only after they produce it, they implemented an additional scent to it, which is why they want to protect that's why there's no other baseball could sell a similar product holding a scent which is of a freshly cut grass. You can sell smells like orange, lemon, banana for all I care, but definitely not a freshly cut grass.
It's like someone selling a shoes with the bubblegum smell or toothbrush.
Exactly. A lot of people have a misconception whereby, oh, I sell perfume, I want to register all my scents for my perfume. That's a big no.
No, yeah.
Anthony, what if if I'm not selling perfume, but I'm operating as a beauty center? When you enter into a beauty center, you can you can smell there is some special like lemongrass or anything.
That one is okay, as long as that scent
Possible?
does not come from your product.
Mm.
The scent doesn't come from your product, then it's okay.
Oh.
Yeah, that's why I think in something is a letdown because a lot of shops have very nice smell aroma, but that aroma comes from their product, which is a big letdown. You can't register that smell. Like Famous Amos, the moment you walk into the mall, you can smell Famous Amos already, just from around the corner. You can say, "Oh, Famous Amos is around." So it's like,
yeah.
then you
True,
just
true.
walk towards it just to get the inch of the smell. But this
In
comes
fact,
from a biscuit.
in fact, I see some small retailers and small businesses, like, home businesses. They say that, oh, you can buy a cookie. It tastes like Famous Amos. That means, it has become so distinctive already. The taste, the smell, and everything. Yeah. So yeah, it's all, at the end of the day, it all boils down to whether it's distinctive or not. I think probably this is what we've been stressing throughout the talk.
Throughout the entire discussion. Yeah. We are not educate. We are trying to make sense on the non-traditional trademark parts. We are not trying to force our opinion on anybody. It's just our 3 points of view, our sense of view. Just up to the public whether they want to accept it, they want to listen, or they have any counter statement to us. They have any counter things to us. They can by all means email us or correct us if we actually said something wrong or inaccurately. We do welcome. After all, we are not really that. Yeah, we are all still learning.
Yeah, we are all learning.
Well, because these marks are pretty much new over here, and I think they are relatively new around the world as well, compared to those traditional trademarks. So, and these marks are slowly gaining significance in the recognition of brands throughout the world. I think there is a certain relevance that it should be promoted, or companies, especially new companies or established companies, should actually look at it, because it's been provided in the law right now. Of course, in terms of how easy or difficult is it to be registered or recognized, then it's another issue. Yeah, and which is up to a lot of discussion. So anyone who has more points or comments can please feel free to type it in the chat box or your Facebook comments.
So far, I see only Mei Fen keep on posing questions.
Yeah, because non-traditional trademark could be an additional layer of protection to their
Yeah, definitely an additional layer.
An advantage and definitely a protection.
Yeah.
I think for established companies, yes, definitely.
Okay, so let's check if there is any question from the floor. It's pretty much almost lunchtime.
Yeah, I can see our participants is decreasing.
How to apply for non-traditional trademark? Oh, that's a good question. And what is the cost, duration of protection? What is the difference between traditional and non-traditional trademark in terms of the cost and the duration?
Well, the cost for our company, I think we would most likely it would more obviously be a slightly expensive than a traditional part of the trademark. But the filing process for both trademarks are exactly the same. It's just a matter whether we tick traditional or non-traditional. But for non-traditional, the moment you tick non-traditional, there are a few extra things we need to be filled in, like I mentioned earlier, a statement, a description. And we still, if client were not able to provide us with the description, we still need to think of a story for them, like help them to draft out the description. So obviously we still haven't, because we don't have any inquiry or even request to file a non-traditional trademark for now for our company. So we don't have a fixed quotation yet. So the cost, I could say that would more likely to be slightly more expensive than the traditional trademarks, but won't be until that higher end, because we only need to complete a few more extra steps for clients.
Yeah, I think the
slightly higher
day,
it's still the same, exactly the same.
Correct. It's just basically for the slightly higher is just because of the fact that we need to compensate to the fact that we spend our time to draft the filing, the copy itself, because it requires us to actually sit down and think, for example, scent or anything, we need to write it out, we need to draft it out. That was an extra step compared to a traditional trademark.
Exactly.
So that is probably why it's going to cost
one part for a drafter and one part for the filer. The filer needs to be aware of what needs to be done, the filer, what needs to be done and what needs to be ticked and what should not be included in the application form during filing stage. So we need to exercise our extra discretion and attention when we're filing non-traditional trademarks. hence why it would be slightly more expensive than filing a non-traditional trademark. But the process of filing is the same. The duration of protection also the same.
Yes.
Because it's not as simple as just words.
Yeah.
Yeah, of course, it's not as
simple.
complicated as pattern. It's not as
Yeah.
complicated as pattern, but it still needs some extra work.
Yeah. So you're paying for us to think, crack our head to actually come up with a draft.
All right. All right, we've come to the end of our discussion for today. So thank you very much to the audience. If you have more questions, kindly contact us by dropping a message on Facebook, our Facebook page, NBS MY, or surf our web, www.nbs.com.my, and post your inquiry there. Yeah. So thank you very much for attending once again. Have a nice lunch. Oh yeah, before I forget, so stay tuned to our next talk. It will be on artificial intelligence and intellectual property. So we will take a sneak peek into the intelligence of
AI.
Okay. That's very creepy. Okay.
All right. Thank you very much, and thanks to all the panelists for your professional opinion. Thank you, and see you.
Thank you.
Bye.
Bye.
Ivy, please remain in the room.